All right, let's see. Hit the buttons, we did the stuff. Looks like it's connecting. It's weird. Who knows what's going on with the internet today? I guess there's a whole IT attack thing. So kind of crazy, but it looks like we are good. Yep, looks like we're connecting. Seems like it's working. So let's get into it. But anyway, I guess it was convention week for WFG's group. So they were out in Vegas, and we had just moved out to Texas. So I didn't get to see anybody in town. But all right, let's hop into it. Some interesting things. So somebody was talking to me about Juan Jaime possibly going over to another company. So we got some stuff about that. We've got some information about some of the text messages. So it looks like Eric was talking to some people who were inside of WFG, getting information that way, kind of a lot of the things that we thought. So that's kind of confirmed in this. And then we'll talk a little bit about some of the designations or information not coming out because of the spouse relationship and some of the conversations they've had. There's more updates on some of that. So let me pull this up and we can kind of get into it. Let me see. There it is. Yeah. Okay. So let's start with this. I just saw this morning. So literally right before I was hopping on here, I saw this on Facebook. It looks like Ray had gone over in July, so just very, very recently, and then Juan Jaime is supposed to be doing a speech over there. So that's not, I can't remember that being that normal. That seems kind of like a weird thing to do unless you're moving, but somebody was asking me about that last week, and I said I didn't have any information about it, and so now looks like that might possibly be a thing. So I don't know. If anybody knows, put it in the chat. I'd love to know if Juan Jaime is actually going over to Experior. Looks like he might be headed over that way. I don't know. It's kind of weird to go over there and do a speech for a competitor. You don't see that very often. I mean, other than, I don't know, maybe like an Ed Milet or something like that, but I don't know, you don't see that too often. So interesting there too. So let's look at where we're at as far as the lawsuits going. So this is the all the court filings. And we got basically up to here the other day. So this is what we're going to be going through today, is going to be them talking about the motion to file under seal and some of the complaints that they have there. There's a couple exhibits in there that show the communications. Most of it's redacted, but we can kind of glean from it as much as we possibly can. These ones don't particularly pertain to us. And then a response from Eric Olson that we'll dive into as well. And that's going to be about the conversation between spouses and what should kind of happen with some of those. And so I'll get this updated on Locals. So if you want any of this information, you can download it from Locals, McKenzylong.locals.com, if you want to stay up to date with any of that stuff, or maybe the videos are enough. But either way, happy that you are here. Hope you've had a fantastic week. I hope it's been great. And we're just going to dive right into it. So this is the first document. This is 203, as you saw that we were just talking about. And this is them talking about the ability to be able to file under seal. And so in here, they have multiple concerns with some of these documents because it's starting to show evidence of some of the things that they were expecting to happen, but because they're being filed under seal, when it's attorney's eyes only, it means that WFG can't see it. So they're concerning about these two exhibits that we're going to look into in just a second that are declarations of Eric Schwalebs, I don't know if anybody knows who that is, which are true and correct copies of a letter from Ellen Elizabeth Dew to Molly Jameson, dated back, that's the attorneys. And so we'll look into those letters and some of the documents that they're talking about. And then there's also an email from Jamie and Molly Jameson back in May 10th. So we're kind of just getting some information leaked from those particular emails, where they're talking about the highly confidential documents and if they should be labeled that. The challenge being is they contain information that would enable WFG to what they call retaliate against current and former agents by enforcing its unlawful restrictive covenants, right? So this is still kind of in quotation marks. Maybe it should be over here. Is it unlawful and restrictive to have a agreement with your agents? We're still kind of talking about and figuring some of that out. And then also, what is quote unquote retaliate, right? If you have somebody that's breaking the law or breaking your agent agreement, is it retaliation then to do something about it when you find that in these documents? And so that's kind of what they're arguing about now. And so WFG concedes that these materials include WFG confidential business information, which you'll see just in a second, that Eric Olson is actually asking for what he knows to be confidential business information. And remember, these documents are coming out from after the termination. So we know that this stuff was going on beforehand, but we haven't been able to get any of that because they're still not releasing any of those documents before the termination, which I think was January 22nd, might have been the 29th. I think it was the 22nd. So this is from after that. So after he's terminated, he's still doing some of these things. And that's the information that we're going to be talking about here, including proprietary business structure, relationships, and other information that, if available to the public, could harm WFG by its dissemination use by its competitors, as well as mobile phone numbers and participants in the communication. So accordingly, the parties agreed that these materials should be sealed. The Olsons have proposed most limited sealings possible to maintain confidentiality while respecting the public's right to information by including certain documents in the filing. And for those foregoing reasons, defendants respectfully request that the court grant the defendant's motions as set forth accompanying the protective order. So the challenge here becomes, well, if the lawyers know about agents who are allowing this ongoing raid to continue to happen, well then, are they not allowed to tell WFG, or is WFG not allowed to have a conversation and to stop these things from happening? And so it's going to be kind of interesting to see as well, because you expect people to kind of move some of their people over, right? Whether it's allowed in the industry or not, or whether it's part of our documents or not, our contracts or not. It's going to be kind of interesting. So if somebody like Juan Jaime, and I don't know for sure if he is going, I imagine people will follow him. And so I guess it's more about how you do it on your way out, right? Are you disparaging the company, or are people following you because of your leadership? And so that's what we've got to kind of see. Or are you specifically targeting people, not just in your agency, but inside of the company? And that's where the differentiation really starts to come with Eric, is that he's requesting these documents and he's requesting stuff that he's not supposed to have from other people. And then he's going and he's targeting certain agents, and he's doing it with disparaging WFG to move these people over. So kind of different than if somebody like a Juan Jaime was just to go to another company. People go, oh, okay, my leadership's leading. I like him. He's the reason why I'm in the business. And so I want to go there with him. Very, very different on the way that that decision is made. So let's look into these exhibits. So we'll get into the first one, and they're a little bit redundant. The second one is more the legal filing that went along with it, but we'll look at the first one because it's got some really interesting stuff in it. Let me grab my pen here too, my marker. So these are some of the correspondence that they've had back and forth between the legal teams. And so they're basically going back and forth on information that they find and different issues that they have. So this is one of the emails that went back and forth. And so they're basically saying that they're talking about the protective order, and they want to challenge Eric and Sandra's confidentiality designations. And we'll look more into this too. They basically designated everything attorney's eyes only. And so it just limits what they're really able to do with any of it. And it makes it much more difficult on WFG to find out what's actually supposed to be in there or not, and then it becomes their burden. So we kind of talked a little bit about that in the last match. It's just a game that you play. I don't know if you've ever done this if you're in sales, or you're trying to pitch something to your wife and she asks how much it is and you tell her it's $1,000, and then you're like, no, I'm just kidding, it's only $250, right? So it doesn't seem like as much money because you start with a high number and then you come down. So it seems kind of like what they're doing is they're like, here, everything is attorney's eyes only. Oh, but we'll back it down, and we only want to keep 250 documents as attorney's eyes only out of those 1,000, but the other 750, we don't mind turning those over as not, right? So it seems like you're conceding position when really maybe only 25 of those documents should have been attorney's eyes only. So they're kind of just good at playing the game, and so they're doing a great job with that. But they're saying that are not confidential and seem designated to further the unlawful conspiracy described in our pleadings, which seems to be extremely accurate. So the document may only be designated attorney's eyes only if they contain information which is so sensitive that the receipt of the information by the plaintiff would have a significant adverse impact on the Olson's business, financial condition, or ability to compete, or otherwise would create substantial risk of harm that could not be avoided by less restrictive means. But in this language, it's very specific to who the harm would incur. And the harm is specifically directed towards the Olsons. So how would it harm the Olsons if they found out that somebody else was in WFG giving this information that they're not supposed to have? It's a tough argument to make. Other than that, seems to be how GFI is able to build its business, is off of the back of WFG. So could you then claim that as being harm? I mean, that's basically what they're doing. They're saying that the Olsons and GFI cannot do their business if they're not allowed to take people and clients from WFG. And that seems to have gotten them this far, which, I don't know, the argument seems to be working. But anyway, this includes trade secrets, financial analysis and projections, confidential contractual relationships with third parties. We've read a lot of this. Identification of confidential consumers, materials leading to ongoing search and development efforts of future products, engineering, sales, training, development, all that kind of stuff. They're not supposed to have any of that. That should be labeled confidential designations that would be limited to specific material that qualifies under appropriate standards. And so they're basically arguing about that. And what they're doing is what we talked about before, is they blanket designated almost 1,000 documents of the 1,215 non-public documents that they produced, right? And that was back on April 22nd. And none of these documents appear to contain information that allows them to be attorney's eyes only. So they're going back through and saying, hey, we need to declassify some of these. And so they're saying it's obvious that from the attorney's eyes only, labeling documents contain only social media platform logos. Like, why would a WFG logo or a GFI logo need to be part of attorney's eyes only? Like, it has no no reason for being there. Internet memes don't need to be classified as attorney's eyes only. Publicly posted videos don't need to be attorney's eyes only, right? Because they're available in the public. Anything you can find, public findings from this litigation. So why are they labeling all of that attorney's eyes only? It's just a delay tactic. It's a mechanism to cause them to have to do a lot more work through the process, because then they have to go through each one of these, and it just creates frustration and prolongs it. But one of these that's coming out, the Olsons have used the protective order to prevent WFG from investigating unlawful conduct by its current and former members. So this is one of the first ones that we've seen that actually shows that Eric is talking to somebody inside of WFG. And so here's a list of some of the things that he's talking about. It doesn't tell us exactly, includes, but it was sometime in 2024, text messages between Eric Olson and, we don't know because it's redacted, who is a current WFG agent. On that communication, Eric Olson asked blank to share a list of the agents in WFG's internal message group. And that's what we're talking happens a lot with the anchor leg strategy, is because one person has access to all this information. So Eric is asking, can you please send me the list of 208 SMDs and above? Can you go into the system? This is supposed to be confidential information is what WFG is calling it. He's asking for it. He says that would help me out a lot, because then I know who to target. I know their contact information, I know all that kind of stuff, so now I know who to go after if I target the SMDs. And if you guys remember, Eric's strategy, or GFI's strategy, was, we'll go talk to the SMD or the leadership. If they don't want to go, well, then we go target the people underneath them, their top producers. We get those people to come over, and now the SMD, now the leadership, is forced to come over or lose all of their income. And so it's kind of, he's playing the game very well. I got to give him credit for that. I don't like the tactics necessarily, so that's just my preference. But and then everything is between you and me, obviously. So not expecting these things to come out. But what they're saying is that he's sending other messages in private group messages platform, and he's encouraging Eric Olson to recruit WFG agents. So part of the reason why they were doing discovery was to figure out if this raid is still going on. And so this is confirming their beliefs that it is. And then as we come down, again, we don't know who's talking to who. Oh, it's got initials TD. Please reach out to him and bring him on. I don't know who that might be. Maybe you guys know who this person is, but they forgot to redact that, I guess. Because was it Eric Yeah, EO is up here. TD. TD. Who do I know that's a TD? I don't know. It's not coming to mind. But maybe one of his big guys over there. So can you please reach out to him and bring him on? It may have to come from you personally. Such and such, the person that they're talking about, gets butt hurt easily, and he may need Eric Olson's ego, and may need an Eric Olson ego message. So if you hand him off to someone else to call, he may not come aboard, just saying. So I don't know if Eric is trying to stay out of it, because this is what he was doing with Eric Carter and DeJuan, is he was basically saying, well, they're independent contractors, they're the one that's doing it, I'm on the outside just watching, I don't have control over my independent agents, they can go out and do whatever they want. And this guy's saying, well, this message might have to come from you might not be able to pass this one off if you really want to recruit this guy. Maybe he respects Eric or whatever it might be, but apparently Eric is the one that he wants to step in and talk about this. So clearly they're still targeting people inside of WFG, and they have help from people inside of WFG. And so on January 31st, Eric was sending this text message to a large group of former WFG agents, then active WFG agents, and 2 currently active W agents. So they are apparently finding out who is active and who is inactive and who is active with WFG. And so apparently some of the people who were receiving these messages are still active with WFG. And basically an announcement that they made through their internal agent portal. And this is one of the big mistakes I think WFG made. I don't know how this helped, right? I don't know why limiting the heritage program helped them in this argument, right? Because the whole thought process, or at least my conspiracy theory about it, I guess, is that this was supposed to stop Eric from doing everything that he's doing now. And to me, it doesn't seem like it stopped them at all. If anything, it's helped people move, because he can then take screenshots of this and say, look, they got rid of the heritage program, so you wanted to put your 10, 15, 20 years into WFG and then go retire and sail off into the sunset, which is what your promise that if you work hard and you build a big business that you can do that. And now that program goes away. That's a big selling point. It seems like, but I mean, that happens a lot, right? If you look into psychology, a lot of the times the things that you try to prevent from happening, you actually make the steps to cause them to happen. So I wonder how much of that is true about what happened with WFG in taking this program away. I wonder how many people left purely because of that. So maybe they caused some of their own issues with that. But anyway, side note. And then this was deleted. Eric Olson had an attachment. Okay, this is just showing that attachment again inside of a group chat. And then he goes on to say you have no ownership, no transferring of codes, lowest comp in the industry, corporate, which I don't think that's accurate either. There's plenty of companies with even less. Corporate company with way too many politics. He might have a point about that. Run by employees who never built anything. I do know that is one of the contentions. That's one of the challenges, is you've got the bureaucracy of a large company who are employees who get to make decisions about the field force. It's kind of that challenge of, it's just that challenge of combining your sales force and having accountability, and a company that is public facing and has to make decisions as far as that goes to shareholders and everything else. It makes it very, very complicated. It's definitely not an easy task to do. This is probably why Linda Fombo just resigned. I don't know, did you guys see anything about Fombo? Was that a true and accurate statement there? It's interesting, because this is old now. As far as I understand, Fombo is still with WFG, unless that's one of the people that's given, unless they're doing the anchor-like strategy. That would be interesting too. I don't know. I don't know if anybody has information on that. But anyway, be very careful listening and trusting professional overriders who haven't worked 10 years plus. They will say anything to protect their incomes, which is fair, right? But couldn't you make the same argument on the other side? Wouldn't you also want to be aware of a person who's trying to build a company and they make their money off of whether you go there or not? So it's like there's conflicting messages on both sides, right? Like obviously, if you've been in the industry a long time, you're in that position where you can live off of your overrides, right? You've built a big business. Isn't that the point of it? So yeah, I understand they're not in the field necessarily anymore, but I think that was the dream that was sold, was that you could put in a portion of your life and then you could, again, sail off into the sunset. And so, but yeah, I mean, valid point, I guess. Just kind of weird how you could spin that around. It would be the same exact way of somebody who's trying to recruit you to a new business because they need you for them to make money. So it's kind of either way, somebody's going to be making money off of you. Even if you go work at McDonald's, somebody's going to be making money off of you. So anyway, again, the truth always comes out, and that's what we're here to find out. So I would love to know more if you guys have that about Fombo. If his wife actually, I wonder if she went over. That'd be interesting to see. We will see you all on the other side, and we will. We will. That's the whole reason why we're doing these, is to find the actual truth. Unfortunately, we got propaganda on one side and nothing from the other side. So we got to go through these to figure out what's actually happening. So by designating this incriminating evidence, attorney's eyes only, defendants are prohibiting WFG from thoroughly investigating the unlawful behavior of its own current agents and concealing the ongoing use of the anchor-like strategy. Given the irreparable harm being caused, we will bring the issue to the court's attention and seek appropriate sanctions unless these documents are de-designated. And I still don't think they've been de-designated. So the Olsons are also using a protective order to conceal their unlawful conduct. For example, on February 27th, the text message exchanged former WFG agent Mario Bayona, who resigned from WFG. Oh, he didn't resign until February. That's interesting. He sent to Eric Olson's Leaders Bulletin. I wonder if he was, because his wife was on Leaders Bulletins, I thought, long before February. So I wonder if he finally just got caught by then. Which he solicited then active agents WFG Austin Harwood, who was terminated in March 5th, who resigned. He resigned, so he didn't get terminated. Interesting. Okay. I need to update my list here. It's so hard to keep track of all these dates. So the Leaders Bulletin reflects the top agents by point production and their upline agents as defined by WFG's Executive Marketing Director and above agent agreement, signed by Eric Olson, Mario Bayona, and Austin Harwood. I don't know Austin Harwood. So basically, this is them showing a leader's bulletin that they took before they left. So this was sometime in January. Again, so they know who to target, right? They're going to go after the top guys, and then also you're able to see who their top guys are, and so you know who to target and how to leverage people. So those individual agents' names, performance data, upline agents fall squarely within the definition of confidential information under the terms of the WFG agent agreement. Thus, all of these guys were all prohibited from using, revealing, copying, and duplicating the leadership data. Nevertheless, Olson demanded even more confidential information. So here's another message between him and somebody else. TD. What was this guy's name? No, it was Austin something. That'd be AH. Okay. So Eric Olson. Who did you get that from? I don't know what they're talking about. Have him send you the base. So he's requesting more information of who's in the guy's base shop. And last month's January base. Okay, so they're figuring out who to target, right? They're specifically seeing who in the base shop. So the base, if you're not familiar, if your company uses other names, that's going to be your agency. So check to see who's in your agency from January, and who's the top performers are. Figure out those people are, and then we want to make sure that we bring those people over. And then Eric Olson says something about clowns. So this is a clear example of Eric Olson soliciting and using WFG's confidential information and hierarchy structure, including WFG's agents, to breach their own agent agreement, as alleged in the First Amendment complaint. Which becomes interesting too, because who gets blamed at that point, right? Like, if you're directed by your leadership to do something that breaks your contract, you're still held accountable, right, for that, right? Like, if somebody goes and tells you to go rob a bank, the hard part is it's kind of convoluted on what you're allowed to do, but they say, hey, go download this confidential information. They wouldn't say confidential information, but hey, print out your base shop. Hey, print out your list of clients as you come over, and you'd be like, oh, okay, yeah, that makes logical sense. It's not like telling somebody to go rob a bank or a gas station or something. Like, that that's wrong. With this, you might not necessarily know that that's wrong. So do you get held accountable at that point as well? It'll be interesting to see in the forthcoming stuff to see what happens. So in another example, former WFG agent Anthony Resendez sends Eric Olson on February 13th email regarding priority changes for GFI's agent portal or website. Attached to the email are 17 screenshots of WFG's internal portal, including confidential payment report, cash flow information. Having been terminated in January, Resendez was required to return WFG's confidential information, including this financial and other data from WFG's internal agent portal. The agent agreement, instead, he duplicated and revealed it to Eric Olson, and Eric Olson used it to modify the GFI agent portal. He used it to modify GFI agent portal. I don't understand why that would be helpful. Internal. Oh, I get it. Okay, maybe they're looking at the structure of their agency. So you come over, you have your team comes over, everything's probably in a disarray because not everybody's getting recruited under the people that they're supposed to. So it builds out that hierarchy. Maybe they use that for, okay, this person was a SMD, this person was an MD, this person was a training associate. So they can put that those designations correctly in the agent portal, is what I'm guessing they were using that for, including its financial and other data, so that maybe they could keep that structure properly as they move people over. So if defendants do not modify these confidentiality designations to allow us to share these documents, WFG will seek relief from the court and appropriate sanctions. And if you think the conversation would be best held resolving these challenges, May 8th, they want to get together and talk about it. So interesting that the way that they're using some of the data. I mean, it makes sense though, because how else would you remember who's structurally, who's under who, how all of that stuff works? If you could see it from WFG's information, bring that over as far as the structure goes, I guess that also helps them kind of coordinate where everybody's supposed to go as far as the leadership structure. So interesting there as well. Okay, and then the second exhibit is going to be more of the legal standing, basically what was submitted. I think we went through this, but I don't remember seeing the document that was in it, so maybe it's a little bit different. Let me get this going. So again, here they're talking about the designation of the highly confidential attorney's eyes only, and they want to make it confidential, which means basically it's redacted for you and me, but everybody else should get to see it. WFG should get to see it. And basically Eric Olson applied those two documents under the stipulated protective order. So remember, there's multiple levels of concealment that's happening here. First, they're not turning over any of the discovery information from prior to the termination. So there's a whole bulk of data that WFG has not gotten, that they have not had access to. And so that's the first layer of disguising the things that's happening. The second is the information that they are turning over they're labeling everything attorney's eyes only, or almost everything attorney's eyes only, which then means WFG is not allowed to see it. And then the third level of concealment is the relationship between husband and wife and the conversation that they're having. So normally that conversation is protected. However, the question becomes, well, if that communication is happening in the furtherance of a crime or fraud or some kind of violation of your contract, does that allow you to still not have to reveal that information just because your spouse is? And generally speaking, it doesn't still become protected. But a lot of times when you see a spouse get on the stand or they plead the fifth because they don't want to get their spouse in trouble by saying something wrong, you're allowed to do that. But the question becomes, if it's in the furtherance of committing a crime or fraud, are you still allowed to use that argument? And that's kind of the point that WFG is raising, or will raise on the next one. So of the 112 non-public documents produced by the Olsons, 978 of them were designated AEO, which prohibits us from discussing those documents and their contents with WFG. And if you can understand the divide that would create between WFG's attorneys and WFG, that you can get in big trouble for leaking information. So imagine the attorneys are talking with WFG and the attorneys are working on stuff, and then they file something and they forget to leave somebody's name out of it. Or they show some documents to WFG which are supposed to be attorney's eyes only. WFG sees it, and then there's somebody's name in there who's still furthering the raid that's going on with WFG. Well, then now the attorneys can be held liable for that. They can get in trouble for doing that because they're leaking data. So it starts to create a divide between their counsel and the people who are, and WFG, right? And so that's not necessarily a good thing. Those people are supposed to be able to have probably some of the most intimate relationships and conversations, probably even maybe more or equal to a spouse, but they're not able to do that if they can't discuss people who are involved in the ongoing raid. Just imagine trying to have a conversation and file things, and you have to tell the judge about it, but also protect it from your own client. That creates a very weird position to have to be in. So, and they're saying the vast majority of those that were turned in, that were labeled attorney's eyes only, had nothing to do with being attorney's eyes only. We hope that the defendants will reconsider their frivolous attorney's eye only designation in short order. They're only asking for immediate, of a couple of them, which is 2 documents, which is the ones that we talked about. We'll kind of run through them really quick. But these 2 documents show that Eric Olson asked such person inside an active WFG agent to provide him with WFG confidential information. And we saw this on both sides. We saw some of the agents in GFI were also asking existing WFG agents to print out client lists, print out all of that information, and send that over to them so they know who to target, they know which business to churn, they know all of that stuff. And so this is a repeat of what we already saw. Can you send me the list of the 208 SMDs and above? And they're saying that these compiled by sending screenshots of WFG's private group message platform and encouraging Eric Olson to recruit more WFG agents. Make sure you bring them over, such and such, whoever this person is gets butt hurt easy. I'd love to know who that is. It's going to be kind of funny. Once that comes out, Uncle Chip, whoever, I don't know if anybody knows who Uncle Chip is, but apparently Uncle Chip is also a participant in a larger group message with Eric Olson and GFI agents, and another active WFG agents. So they've got messages going on currently with WFG agents who are still in those messages, and they're labeled here, but they're redacted. In a January 31st text message conversation amongst that group, Eric Olson shared confidential information. These documents are just the latest examples of the defendant's anchor leg strategy, which families members use, typically husband and wife, but here uncle and nephew. Oh, so I mean, they kind of see, this is the hard part, is they kind of ratted on themselves here, right? Because they're talking about Uncle Chip, and then they're saying this proves that the anchor leg strategy is for family members, and then they say uncle and nephew. So probably this person is going to be whoever Uncle Chip's nephew is. And so if that person's still part of WFG, they're giving information to their uncle. See how hard it would be for an attorney to like make sure you cover all of those things up, because they probably should have redacted this as well, because now they told us basically who that person is without actually telling us who that person is. So to raid WFG's agent base and send them WFG's confidential information to its competitors, GFI. We expect there are many more instances of confidential information being sent to GFI prior to Eric Olson's termination from WFG, but we have not been able to confirm that, given the Olsons have refused to provide documents dated earlier than Eric Olson's termination date, which I believe was January 22nd. So the defendant's counsel has refused to remove the attorney's eyes only designations on these documents because they fear WFG will retaliate against such and such for breaching his agent agreement. This fear does not support an attorney's eyes only designation under the Section 2 and 2.1 and 5.1 of the protective order. Rather, only documents that contain information so sensitive, blah, blah, blah. We talked about that. So these documents contain only WFG's confidential information. In short, the defendant's tactics have placed us in an untenable position of not being able to share this ongoing and irreparable harm with our client, WFG. And they actually even just broke that on accident. They didn't even mean to, but they said uncle-nephew relationship, and now we know who that person is without, obviously WFG would know who that person is. And so that makes it really hard to have a relationship and talk about things if they're constantly having to protect themselves from what they can say from their own party. So meet and confer agreements, these are some things that they want to get together and talk about. The parties conferred telephonically within 14 days on May 9th, which time WFG explained that the resolution of the designation of these few documents was urgent and asked defense counsel to consider redesignation of these two documents on an expedited basis. Defense counsel agreed to review the documents but refused to provide a date certain to do so. Accordingly, WFG attached the two documents at issue and asked the court to remove attorney's eyes only designation since defense counsel will not do so. And so those are the two main documents that we've seen and we've been talking about as far as 12853 and 14007 that they've been arguing about, that they want to release those so that they can actually show WFG those conversations. So interesting what's happening there too. And it seems like, because the documents I would have sworn we read last Friday were still complaining about these two particular documents, but maybe it was different ones. I didn't catch the numbers on there. But potentially even, I don't know, almost 2 months later, we're still arguing about the same thing. So all of this really, I don't think it matters to GFI, right? Like, it's all just a prolonging tactic. As long as they continue to get the people that they want and they have the ability to get the confidential information that they want, target the people they want, I don't think they really care about the result of the lawsuit. So every day that this ticks on is better for them. It helps them because they can continue to do it until the judge actually tells them to stop doing something. And we haven't had any of that happen. And I don't see it happening necessarily anytime soon. So, all right, let's go into the last document that we're going to run through. And this is the argument, I believe this is Eric Olson and Sandra's side of why they feel that there should still be confidentiality between husband and wife. And generally that's kind of a sacred ground that you can't really go. But the question becomes, if they were furthering a conspiracy, does that still remain to be protected if what they were doing was clearly wrong? So we'll see kind of their side of it, and then WFG will probably respond for next week. So defendants Eric and Olson respectively submit the response excuse me, to WFG's letter brief. After moving to compel on virtually every other aspect of discovery, WFG's third unilateral filings challenged the defendant's assertions of spousal privilege. Its argument lacked substantial justification for at least 3 reasons. So these are the 3 reasons why they're saying that they should not be able to look into these conversations between husband and wife. Number 1, Hornbook law that in diversity cases such as this one, privilege is granted by California law. Here's the code for that. In diversity actions, questions of privilege are controlled by state law. but in a civil case, state law governs privilege regarding a claim or defense of which the state law supplies the rule of decision. Number 2, it is equally well established that the privileges in California are statutory and courts cannot create judicial exceptions on them. Wells Fargo Bank and Superior Court is what they're citing. The privileges set out in the evidence code are legislative corrections, and the court of this state has no power to expand them to recognize implied exceptions. WFG mentions neither of these basic rules and instead urges the court to carve a judicial exception in California's marital communications privilege based on various federal cases, contrary to the legal standards that it avoids explaining in its brief. Third, WFG also makes a throwaway waiver argument that is woefully unsupported. For all these reasons, its motion should be denied. You can do literally anything in California. It's kind of funny. Well, I guess it's because it's happening in California that they talk about that. It might be the same in other states. I don't know. So anyway, WFG's attempts to create an exemption to privilege lacks substantial justification. So under the California law applies to questions of privilege because every claim in its diversity case arises in California law. Under the California law, the Olson's confidential marriage communication are privileged. A spouse, whether or not a party, has a privilege during the marital or domestic partnership relationship and afterwards to refuse to disclose and prevent another from disclosing a communication if he or she claims the privilege and the communication was made in confidence between him or her and the other spouse while they were spouses. So even after you're divorced, you can still claim privilege over the messages that you had while you were married. WFG does not contend that any entry in the Olson's privilege log was not confidential marital communication. It argues instead that the court should create an exception to California Evidence Code 980 to exempt business communications. This argument lacks substantial justification because California law does not allow courts to create exceptions to the privilege. So it kind of creates an interesting position here, but this is also protects the anchor-like strategy, right? Because you have one spouse in one company, one spouse in the other company. Legally, what they're saying then is you can send all of the confidential information you want between the two of you because it falls into the privilege of a spousal communication. WFG's side of that is, well, they weren't communicating as spouses, but they were communicating as business partners. They just happen to be spouses as well. So does that put the communications in a different category? Even though they happen to be spouses, they're not talking about spousal things, right? Like you wouldn't want information coming out, it wouldn't pertain to a case if one of them was going to counseling and needed help with certain things and they're providing private details about their life in a spousal communication. However, just because they're spouses and they talk about business that has nothing to do necessarily with their personal life and their personal business, does that fall into a different category? That's kind of the things that they're arguing here. And so obviously GFI's counsel's standpoint on that is all communication between husband and wife or spouses is entirely protected regardless of what it is. So because privilege in California are statutory, courts cannot create exemptions to them. They're going to provide some case law here. Not only is this basic tenet, but cases that WFG neglects to cite have made this very point about spousal privilege. See People versus Bearfield. Because the statutory language and the marital privilege and its exceptions is clear, and because we have no authority to imply the existence of an additional exception to the privilege, we must hold that MW's claim of marital privilege is lawful. This principle, which would be interesting, right? Because if you had a husband and wife, and the husband is in business, and he's confiding in the wife about committing crimes, but the wife is not in the business, right? It's clearly still spousal communication. but then you take that other person, you put them in business as well, does that allow them to continue to, or is that information then going to be protected? So I guess it would be smart that you set up a business license with your spouse and with your spouse, then you rob the bank, and then that way all of the communication between the two of you cannot be turned over, because all the conspiring that you did gets protected into that designation of you being husband and wife. So that's a great way if you further want to commit crimes, which I don't recommend. But if you want to do that, there's a great way to get away from all. Now, in California, can you be married with multiple people? So I guess you just marry all the people that you want, and they don't care about husband and wife at that point too. So you could marry your friend or multiple friends, go commit crimes, then everybody claims that they have spousal privilege, and then nobody has to turn over any information on any of that. So there's a good way to get around the law at that point. So anyway, this principle even remains true in situations unlike this, where applying the privilege literally would arguably create an absurd result. We are aware of no published opinion where a California appellate court construing an evidentiary privilege has implied the existence of an exception to the privilege by exercising its authority recognized in California State's Employees Assignment. So, but I wonder if being in business together changes any of that. They're obviously going to say that it's not, even if it does, but that's what WFG will obviously claim. So, not to follow the plan meeting the privilege statutory language, where doing so would result in absurd consequences the literature did not intend. WFG cannot point to any statutory exception to the marital communication privilege and concedes that no such exception exists. So that makes the anchor-leg strategy even more powerful, that you can just do whatever you want as long as you're communicating it through your spouse. WFG cites no California authority to support this argument, nor does it explain that California law does not permit fashioning any exemptions to statutory privilege. According to WFG's argument, lack any much less substantial justification. The federal cases WFG cites do not support its request relief. Yeah, we got some good points there. We'll come back to your guys' comments here in a second too. Let me just finish this part, and I think we're almost done. Okay, so while they should not be considered for the reasons stated above, the various decisions WFG cites do not support the exemption. It asks the court to fabricate. The case from Oregon has a motion to compel the production of a privilege log to establish the existence of the privilege. It did not purport to create an exemption to marital privilege, so they're saying that doesn't relate at all. Concerned the application of New York law to access the location and existence of bank accounts to determine whether the defendant had fraudulently transferred his assets to his wife to avoid paying judgment. After the plaintiff had already won the judgment, and after the judge found the defendant had defrauded the plaintiff, the court ordered the wife to answer interrogatories because the location or existence of a bank account was not presumptively confidential. It also is not a communication. Okay, so in contrast to the cases it cites, WFG seeks disclosure of private text messages containing images exchanged between husband and wife. Contrary to WFG's arguments, the inclusion of private images shared via text messages between spouse readily implies confidentiality as reflected in Olson's private log. So if you're sending because that was part of the challenge, right, was that Sandra left first, and then Eric was simultaneously, through his spouse, part of GFI and part of WFG simultaneously. So he was then sending information to his spouse about it, and so they're saying all of that should simply be protected because of that relationship. WFG simply presumes the communications at issue are business communications, but cite no evidence to support that assumption, which is separately fatal to its motion. People versus Carter and Any communication between husband and wife is presumed to be confidential, and the burden is on the opponent of the privilege to prove otherwise. So the question there becomes, does being in a business relationship change that confidential status? And if it changes that confidential status, it would only be for things that pertain to business, which gets really complicated to think about it because, if you're like me, you and your wife, you often have multiple conversations happening simultaneously, right? So you're talking about one thing, she replies to something else, you reply back, it's like multiple questions. So then inside of that communication, what actually becomes relevant to being confidential and what is not, what becomes business, that would be really hard to separate. But clearly, if you're sending WFG confidential information and it's a screenshot, it's a picture of the hierarchy and the order of it, would that fall outside of spousal privilege? I don't know. Nor is there any basis to comply a conspiracy or third-party fraudulent exception to marital privilege as WFG requests. Well, okay, so this is getting into WFG's belief system then, because obviously they are committing a conspiracy, right? Because they are conspiring together, and then they're conspiring with other people to use that data in a way that allows them to build their business. So what GFI is saying is that first, WFG again relies entirely on a case that applies federal common law or the law of other states and asks the court to create a judicial exception to California statutory privileges. So apparently maybe it's different in California than it is in other states, so that's going to be interesting too. Second, again, the case law WFG cites does not support the exemption it seeks. Oregon case WFG cites this. Has only recognized an exception to marital communication privilege having to do with present or future crimes in which both spouses participate. So, according to, where was that? Oregon. In Oregon, if you're committing a crime, you're in the presently or future crimes that you're working on committing together, then that communication is no longer allowed to be confidential. For statements between spouses relating to a crime, whether the spouse's children are victims, where a spouse's children are victims, such an exception cannot apply in the civil context where Olsons are not facing criminal charges of any kind. So that becomes interesting then. So if you then file, because WFG is not necessarily alleging a crime at this point, although it's fraud is what they're looking for here, because it hasn't moved to an actual criminal case, they're saying that that doesn't apply because this particular one was a criminal case. Does breaking a contract take it outside of civil and put it into criminal? I don't know. WFG's allegations of unlawful fraudulent scheme is what they describe as an anchor leg strategy. This refers to WFG's allegations the Olsons hired the spouses of people working for WFG to help recruit them. WFG also argues that the defendants violated the confidentiality restrictions in their employment agreements. These claims are all for breach of a legal covenant WFG seeks to enforce. The practice of spouses working at separate companies is not unlawful under any criminal statute. You see that? So that's how they get away with it. They say they're working at two different companies. How can that possibly be unlawful? To be sure, even WFG's president testified that such a practice was not restricted by any rules that he was aware of. Well, yeah, of course. Like, what company is going to say, well, husband and wife cannot work at two different companies? That's stupid. Like, probably almost everybody in America, unless you run a business together, you are going to work in two different places. So they're kind of taking it to the absurd here. That's one of the benefits of being in our industry is that you can do it, your spouse can do it, they don't have to do it, they can work somewhere else, you can do other things. So they're kind of using that really out of context, but I don't know if a judge would really be able to understand the difference. So not saying that judges are dumb, but just it's a very different structure that our industry is in than most industries. I'm not aware of a rule that says what a spouse can or cannot do in response to whether spouses are prohibited from working at competing companies. Yeah, but there's a difference between working at competing companies and sending over information to target agents from the other company. So again, they're taking that to the extreme, saying, well, they're trying to say you can't work at separate companies. It's not that you can't work at separate companies, it's that you cannot leak information from one company to another company to profit your own company, especially. It's not that she works in it, she owns the other company. And they're using information that they're collecting from one company to benefit, to cause a loss in one company to benefit the other company. Answering no, are you aware of any WFG rule that prohibits the spouse of WFG working at another company? She said no. Shorek also apparently answered this question as well, saying no. He was questioned whether he was told that if husbands went to GFI, would not be able to work at WFG. These allegations cannot be basis to apply a new exception to the marital privilege, except for when you're taking from one to give to the other. It's not simply just working at two different companies. It's not like Eric is working in WFG and Sandra's a babysitter, right? Like, that wouldn't matter. But when they're sharing the confidential information, that puts it into an entirely different category, at least in my eyes. As far as the law, I don't know. Finally, WFG claims that an exception should only apply because the Olsons are colluding to frustrate the discovery process. That's true. And the court's discovery rulings, however, do not support this theory. The WFG waiver argument lacks substantial justification. First, it's unsupported because it offers no proof that the Olsons have put an issue that their confidential marriage communication, the 2 paragraphs of the Olsons' declaration that form the basis for WFG's waiver argument, do not describe the conversation between Mr. and Mr. Olson, and thus could not affect the waiver through their voluntary disclosure. Olson resigning from WFG, describing on a WFG meeting with multiple WFG agents. WFG has not shown that the Olsons have used marital privilege as a sword in any way, except for their collusion to raid WFG. Other than that, they have not shown any way that they're using it as a sword. To date, the Olsons have produced thousands of responsive communications. WFG's desire to obtain private text messages between the Olsons, including images exchanged between spouses, lacks a legal and factual basis as such, only seeks to harass the Olsons and embarrass the Olsons. So again, we go back to that. I just watched a great movie. It was called, oh my gosh, The Report. If you guys get a chance to watch it, it's so good. So good. And it shows the incompetency of our government and the way that they hide stuff. And one of the things they talk about in there is that one of the ways that the government gets away with not really being looked at is they turn the focus onto the other person. So if you're alleging something of somebody, well, what you do is you turn that around and then you allege something of the other person, right? It's like diversion tactic of who's doing what, right? Because you're getting attacked. You see this a lot on social media. Instead of defending the argument, you attack the other person. And so it changes the perspective. So in this particular case, this guy kind of leaked some information that the government was doing things that they weren't supposed to be doing. The CIA was out of bounds like it normally is. And what the CIA did was then sued the guy. And so then he's now distracted with this whole lawsuit that he can't really do anything about. And so that's kind of what they're doing here, is they're saying that you just want this information to harass us and embarrass us, not because you actually want to see about this raid that's happening. Second, under California law, privilege can only be waived if the holder discloses significant part of the communication has had consent to disclose. The Olsons have not disclosed significant part of the substance of their private text messages, communications, and do not otherwise consent to such a disclosure. Third, the cases WFG relies on do not concern marital privilege at all or involve completely different circumstances. Well, yeah, they probably haven't had this happen before, where husband and wife conspire together to raid a former company. I would imagine that is pretty rare. Finding blanket claim of attorney-client privilege unacceptable. holding waiver of attorney-client privilege, where the party distributed privileged documents to unrelated parties. So they're just going to go through a bunch of case law here to argue that the Olsons have waived marital privilege over the subject text messages because the Olsons' business dealings are at issue in this case, leaving aside that WFG has not shown that any of the texts involve business communications. However, that might be defined. The Olsons have not placed their confidential marital communications at issue. Their communications to others in the operation of the business are not confidential and are not part of this case, but what they say about the work and privacy of their marriage is not. In the same way that litigations privately discuss and strategize about their matters at an issue in their court cases with their counsel without waiving privilege, spouses are free to discuss their work with each other without fear of waiver, even if the third party later decides to sue them related to their business. As with attorney-client privilege, spousal privilege derives from the nature of the relationship between the people engaged in the communication, not the subject matter of the communication. Unless they're breaking the law, is kind of what they're saying, but it's not a criminal suit, it's civil, so that doesn't necessarily apply. But how does that work then, though, when they're conspiring together? They're saying that it should all be covered. So, rallied upon the attorney's advance to defeat, I don't know what that is. The Olsons, in contrast, do not contend that they relieved on confidential communications with one another to establish or defeat any claim in this case. In reality, WFG's waiver agreement is simply a redux of its efforts to carve a judicial exception into the privilege because of accepted marital communication privilege would be implicitly waived at the time of someone sues a family business. Because I think it would be really helpful. Obviously, I'm not for big government and government being in people's stuff, but if spouses are conspiring to do something, that information could be very helpful into seeing why they did it and what they actually did, right? Because imagine the communication that's happening between the two of them if she's going to start the company. If he's saying, well, that you should start this company because we can move all of our people over from the former company and we can churn all of these clients, well, he's admitting that their intent was to commit fraud, right? Which would obviously be helpful, but I don't even know if they'll need it because I'm sure he's had that conversation with so many other people. So it would be helpful and it would help tie the two of them together, but I don't know if WFG really needs it. But imagine if they had that communication of what they're saying and why they're doing it and the disparaging things that they're saying. That would be a huge help for WFG because I'm sure there was a lot of that conversation that happened that was business talk and not spousal talk. So WFG demands for in-camera reviews lack substantial... Oh, so I guess they did not do it. There's no exception. So remember how last week, I think on the 10th and the 11th, they were supposed to get together and they were going to do in-camera meetings with both the Olsons? I don't know if that happened. In WFG's demand for in-camera review lacks substantial justification for all these reasons. So I guess they're disputing that. So I don't know if that actually happened. There's no exemption to privilege to apply. The exemption WFG seeks is unsupported by law. WFG did not provide any evidence with its moving papers that would establish such an exemption, and this demand also lacks substantial justification for the independent reason of California law. So anyway, they're saying that the communications between spouses and domestic partners, even those in business together, have always been sacrosanct in California, meaning they're sacred. WFG's effort to attack the legitimacy of this bond without explaining the applicable law and without citation of evidence is part of a broader inappropriate effort to grind down the side with far less resources. WFG's motion lacks substantial justification. I think it would, I don't know how it's supposed to grind them down, but obviously, again, you change the viewpoint, saying this person's attacking me and they're doing it outside of any merit just to grind us down, and which does happen, especially if you get in a lawsuit with the government. They just try to grind you down and prolong it as long as possible because they have all the resources and you don't have any. So it makes it easy to do. But anyway, that's their justification as far as what's going on the confidentiality. So we had some good messages here I want to read to too. So John Sent said, I feel like WFG has changed a lot in the last few years. It's become too corporate. I have to say, John, I don't know if you're in WFG or not, but that's been most of the complaints that when I talk to people in WFG has been the challenge. And I think that's an industry thing, right? Because it's easy to not be corporate when you're small. When you're a small company, you're 7 or 10,000 agents, you don't have securities products, you just sell insurance. It's pretty easy to not have that corporate feel to it because the standard of that is basically your license. So there doesn't have to be a lot of oversight from the company because your license kind of takes care of it. But you add in the size of WFG, and I think they're wanting to be, from my perspective, kind of looking in, is that they want to be more of a brand, more of a household brand. Transamerica already is. They have great reputation in the industry, all of that kind of stuff, probably one of the best. And so in order to carry that name and that brand on and to be seen as a more credible company in the eyes of families, because that's one of their mottos, right, is they want to be in every household, they want to be a household name. Well, the way that you do that is you have to kind of become more corporate in that people are getting the same experience. You can't have rogue people going out there doing whatever they want, which unfortunately takes away that side of kind of being an independent contractor in our industry, all the great benefits that it has. It's a battle between the two of those, and that's got to be really hard. I'm glad I'm not on the leadership of a big company like that. That would be really hard to do. So spousal communication could prevent monopolies or contribute to their creation. Yeah, that's a good point too. So all you have to do, marriage doesn't mean a lot to a lot of people these days. So I guess all you have to do is get married with the person. It also specifies they don't have to even be the opposite sex as you, so it could be a business partner. You just get married with them. You create your monopoly and you have the conversations that you need to have between the two of you, and then it's all protected speech. You don't have to worry about it. So you don't have to do that. Oh, here's a confirmation on Fombo. So Fombo spoke at convention. He was amazing, and his wife Linda was there as well. Beautiful couple. His sister also is in the business and spoke at the convention. They showed lots of gratitude. Okay, nice. So maybe that was one of the false disparaging statements that Olson was making, was that the Fombos were leaving. I know he was saying that early on. So that kind of goes into another category of lies that he was saying about people and didn't actually end up becoming true. So interesting. Okay, well, thank you, Christy, for that. I appreciate your guys' message and helping out with some of those things. So I guess Fombo is still with WFG. It's kind of sad to see Juan Jaime going. I think he's going over to Experian. We kind of talked about that in the beginning. But it'll be sad to see him go. He seemed like a good guy to me. I didn't really get many interactions with him. But it looks like if he's going over to... He might just be speaking there. I don't know. I could be speaking out of place here. Maybe he's just going to go speak over there. It just says guest speaker. It doesn't say, his position or anything, but kind of weird for somebody to go speak at a competitor's thing. You don't see that happen very often, but doesn't mean it couldn't be what he's doing. He's done a great job in the industry. He's built a big business and seems like a good guy. Seems like a lot of people care a lot about him. Everybody I've talked to in his team really loves him, and they have a lot of respect for him. They look up to him. They know he's honest and he does the right thing. So who knows? We'll see what happens. But anyway, that's all I got for you guys today. Hope you have a fantastic weekend. Hopefully you got everything knocked out today and you can just relax this weekend. Appreciate y'all. If you were at convention, I hope that was great for you guys too. And I will see y'all later. Take care. Bye.